Good afternoon, everyone. My name is Meri Ros. I'm one of the partner attorneys over at Rossen Law Firm, and myself and the rest of my partners are going to give you a presentation today about sex crimes. My part specifically is about motions and arguments. Again, by sex crimes, we're referring to not just crimes against children, but also against adults, although the majority of the motions do focus on children because that's just a very specific part of the law. And give you a little background about myself. Again, my name is Meri Ros. I go by Meri. I'm one of the partners here. I'm board certified criminal trial attorney. I have been doing criminal defense for about 14 years now. Spent a large majority at the public defender's office, so I was able to see a lot of these cases, and I have tried several capital sexual batteries in trial, as well as other sex crimes. All right. So when we talk about motions and arguments on sex cases, one of the biggest issues that you are going to be dealing with is called Williams Rule. I'm sure most of you have heard about this. This is actually the state's intent to introduce prior bad acts or character evidence or previous convictions or uncharged crimes. Normally, those are not admissible. So when the state does this, it's generally called Williams Rule. I could spend probably an entire presentation on just Williams Rule. So obviously we're happy to help with any other questions you have in the future. I'll post all my information at the end. Feel free to email us. These slides are by no means completely comprehensive. I'll be going over a lot of things that are not on the slides, and there's a lot of things that I won't even have an opportunity to go over. Williams Rule, which is actually Florida Statute 90.4042B. It's actually the state's intent to offer evidence of prior crimes or bad acts. Now, they are not admissible. Generally in trial, prior bad acts, prior crimes are not admissible unless the state files this. They must, pursuant to the statute, file this no less than 10 days prior to trial. You might think that that never happens. That's incorrect. I had a case where the state filed it 6 days prior to trial, and I did a written objection because the statute is very clear, and the judge did not admit their Williams Rule. Now, when they file this, again, this is going to require almost an entirely new case. Because what Williams Rule is the state is going to try to bring in, so the jury can hear, an entirely different crime. They're going to have entirely different victims that they're going to want to testify at the trial. And obviously, these are prejudicial because you're talking about a molestation case. You not only have the victim on your actual case, but now you're going to be dealing with one or more victims who will be testifying in front of the jury that your client did something to them as well, that the jury is not there to find guilt for. Now, Ms. Lawson, one of my partners who will be presenting later on, she'll be discussing how to attack this in front of the jury. It is very tricky and you must address this. That's why you need notice, because when you have this, you're going to file, like I wrote here, a written objection. Be specific in your written objection. The state, when they file their notice of intent, they're going to throw the entire gambit of the ways that Williams Rule should be introduced here, and I'll go through each one of them. I, in filing my written objections to Williams Rule, go through every single one and attack why it is not relevant to this case. So let's go to the next slide. Now, these are, again, it's at least one of these, but they are not limited to. There's others such as corroboration, which the state always uses, and corroboration is usually one that they can get it under because the victim, when you have a sex case, generally there's not a lot of evidence. I'm sure you'll have DNA, but the majority of the time it's going to be a he said, she said situation. And so when you have a child, then it's generally understood. Children are not going to be as specific, especially if I had a case with a 5-year-old. So a 5-year-old is not going, is incompetent to testify by law. So they will bring in sometimes a Williams Rule in order to show that your client did something similar. But the list, and again, it's not an exhaustive list of what they will include, and they're going to include each and every one of these in their motions, in their notice of intent to introduce Williams rule. So the first is that the crime is inextricably intertwined. Now, this is actually used not just in sex cases, although that is today's focus. Anyone who has done Rock Court or repeat offender court knows that the state tries to bring in Williams rule for every type of case. One of them is that they say that the previous bad act or the previous crime is inextricably intertwined in order to prove their case. Now, in order to show that something is inextricably intertwined, they have to show one of four things. The first is that the previous crime is necessary to adequately describe the deed. Second is that it's necessary to provide an intelligent account of the crime charged. Third is that it's necessary to establish the entire context out of which the charged crime arose, or number four, that it's necessary to adequately describe the events leading up to the charged crime. The seminal case on this, and I can provide some of these after, is Scott versus State at 957 Southern 2nd, 43, and that's a First District Court of Appeal case from 2007. So, what does that mean? That means that they might try to bring in anything that would lead up to it. So if you have a victim and perhaps her sister claims something happened or that her sister was told something, they're going to try to bring that in as necessary to show the events leading up to it. So in Scott versus State, that was actually a case of felony murder by aggravated child abuse, where the state was trying to bring in evidence that the child had a broken leg, the child was in a body cast. But again, the question is it necessary to prove the crime charged? Because all of these are going to be inherently prejudicial. We're talking about telling the jury other crimes that your client has been accused of, or that your client, or uncharged crimes, or prior convictions. So they really have to be relevant and necessary as inextricably intertwined. In the case of Scott, even though it was felony aggravated child abuse, the court determined that the evidence of the broken leg was not necessary to show because that broken leg happened a month prior and it wasn't actually a part of the murder. Again, the state is just showing that your client is a bad guy. They don't say that that's what they're trying to do, but that is obviously what they're trying to do. And so, and additionally, in Scott, they were trying to show that the child was forced to stand on one leg in a corner as part of the punishment. But again, the court said that's not Williams' rule because that form of punishment didn't necessarily constitute aggravated child abuse. And again, this is a felony murder by aggravated child abuse. So they have to show that whatever they're trying to bring in, that they need it. That basically that without it, they just cannot prove their case or they can't present the whole picture. And we're going to go through this after as well, but no matter what, whether or not they prove inextricably intertwined, identity, absence of mistake, any of those, whether or not they prove them, there's still the analysis of does the probative value, is the probative value outweighed by the prejudice? Because again, if the probative value is not sufficient and the prejudice is too great, even if the state meets any of the prongs, the court can still exclude it as overly prejudicial. I will go back to the slide so we can go through each one, but let me go to the next slide. Now, when you do your objection to the state's notice of intent, again, make it specifically, go through each of the factors because the state will include each factor, although they won't be specific as to why they feel each one is relevant. So for example, if they're saying it's identity, one of the arguments is, look, identity is not an issue. They knew each other. There is not a question about who did this, right? Because it's the child's father. Another one is intent or knowledge, right? Now, they love saying that, well, this is necessary to show the intent. This is necessary to show knowledge. However, the majority of sex crimes, such as lewd and lascivious battery or sexual battery, lewd and lascivious molestation, those are actually general intent crimes. They are not specific intent crimes. So I write in my objection, intent and knowledge, they're not issues in this case. The fact that they don't know what they're doing is wrong, that's not an argument. That's not a defense, right? We all know that it doesn't matter if the child came on to you, if the child wanted it, if you didn't know it was a crime, if you weren't aware of their age. Those are not necessary. Those are not defenses. So for them to try to bring in priors just to show that they knew that this was wrong is irrelevant. And again, the probative value has to outweigh the prejudice. And one of the cases for intent just to show whether it's a specific intent or a general intent crime, is Buford versus State. That's an old Florida Supreme Court case from 1986 at 492 Southern 2nd, 355. For the next one, and again, I'll go back to the list so we can. All right, just so you understand, once you file your written objection, then there's going to be, you're going to request a hearing. I request a hearing in my written objection, as the state at that point will have to look their Williams Rule witnesses, who they intend to call to show these priors. And then you take their deposition. In Florida, we're allowed to take depositions, so that's what you do. You treat them as any other testifying victim, because that's what they will be. Although the jury consider them as victims, they're going to testify as victims, and the jury will hear it as such. You take their depositions, you do your investigation on these witnesses like you do everyone else. And once you take their depositions, then you have this hearing to determine, again, the state has to show by clear and convincing evidence whether or not they meet any of these. All right, so for a Williams Rule hearing, before the Williams Rule evidence, it is incumbent upon the trial court to make multiple determinations, and these include: one, whether your client actually committed this prior crime. Because again, we'll go over a little later, this doesn't actually have to be a prior. These can be uncharged crimes. In other words, a victim can come out of the woodwork and say, look, I never even went to the police about this, but your client molested me when I was a child as well. And obviously the jury hears this and it's very prejudicial. So the court then, at the Williams Rule hearing, has to determine if it's an uncharged crime, no prior conviction. They have to determine by clear and convincing evidence whether your client actually committed this prior crime. This isn't beyond a reasonable doubt. This is clear and convincing, higher than preponderance, lower than beyond a reasonable doubt. Number two, whether this prior crime meets the similarity requirements necessary to be relevant. And again, those similarity requirements are what that previous list was: intent or knowledge, a common plan, opportunity, absence of mistake. The biggie is modus operandi. I'll go over that a little more, but the court has to determine whether these are actually similar enough. We'll find cases where they say, well, it was too long ago, or the ages are too different, because if one is a 5-year-old or an 8-year-old, and then the testifying victim for Williams Rule is 16 years old, that's a big difference. Because again, as far as modus operandi goes, the state's trying to say your client is a child molester. A 16-year-old is charged as unlawful sexual activity with a minor versus a capital sexual battery for a 5-year-old. So you as the attorney must distinguish all of these to the court. Make them as different as possible. Number three, whether the prior crime is too remote so as to diminish its relevance. Again, something happened 10 years ago, and someone comes out of the woodwork, they never went to the police, and 10 years later they're saying this happened. That's too far away. And again, not only does the court have to determine whether they actually committed this crime, why wasn't this reported, but something that happened 10 years ago, how much probative value is it really going to have as far as this case goes? Again, it cannot be that the state is proving your case only through Williams Rule. That is only if they're going under the inextricably intertwined, but that means that it is absolutely necessary to prove their case, that they cannot prove their case without it. And finally, no matter what, one of the determinations is whether the prejudicial effect of the prior crime substantially outweighs its probative value. This here is your money argument. This is always where you're going to be focusing on. As rates of recidivism for child abusers, child molesters, everyone knows that those recidivist rates are very high. So when a jury hears that your client has done this before, the evidence that they have in the case in chief is not really going to matter. And although they're not supposed to convict based on Williams' rule, they will. We all know they're humans. So again, this is one of the reasons you really have to voir dire a lot if there's going to be Williams' rule evidence. And so again, as mentioned before, whether evidence can be properly admitted as Williams' rule is highly individualized, factually intensive inquiry. There are lots of cases for Williams' rule. It's called Williams' rule because of 1956 case, Williams v. State. The cases that people really cite to now are McLean for child abusers or child. So I said earlier, you really want to focus on the differences between those crimes and the current. So if in your case, your client is charged with a molestation, lewd and lascivious, against a child, and they're claiming that this was grooming. Grooming is something that you see a lot in child molestation and sex cases involving children. And if there's grooming, that's very, very specific. That is, psychologically speaking, something that child molesters are known to do. So if you have someone coming out, I had a case where there were two victims, and then there was a third one, which was Williams' rule. Victims were his twin daughters. The Williams' rule victim was a cousin. The way it happened with the daughters was very similar. They were charged separately. They were Williams' rule witnesses on each other's cases. They were twin girls, and really the molestation charges were almost identical. We had the full hearing, but it was impossible to keep that out. What we were able to successfully keep out is the cousin, because the cousin's case was very different. There was no grooming. With the twins, it was that it started when they were 10. It started off as touching, then it turned a year later into anal sex, then into vaginal sex. There were Bible verses that were quoted, really very identical fact patterns. However, for the cousin, it was a forcible rape that's in a car in a parking lot. So we were arguing, look, if you want to charge this, it has to be a separate crime, which they ended up not charging it, but that it could be used as Williams' rule evidence because it was completely different. I mean, yes, they were both of minor children related to him, but one was a single encounter in a car that was violent, it was forceful, while the other ones were grooming. It took time, it was over the span of years. So again, it is a very factually specific inquiry that you have to go through in the case and show, as the attorney, as the defense attorney, you have to highlight all offenses. Again, where the conduct occurred, right? Was it a parking lot or was it at their house? The age of the victim. Again, because if the modus operandi that the state is suggesting is that your client likes them very young, under 12 for, or I'm sorry, 11 or under for capital battery, and they try to bring in a 15-year-old, a 14-year-old, again, we're going to say that that's not enough. And judges know, and you have to argue it, that really what the state is just trying to do is show your client's a bad guy, to show that your client just intends to molest children is what they're trying to show. The burden of proof. So again, it's the state who is trying to assist. It's actually whoever is offering this evidence. The offering party is the person that has to show that these prior acts by clear and convincing. And the reason it says the offering party and not just specifically the state, defense attorneys can also do Williams' rule. I've done that before. It's called reverse Williams rule, where you're trying to bring in that this other person has, that this victim has lied before, or that this victim has done other things before. Again, Williams' rule is something that you can both offer. It's usually done by the state. I'd like to throw that in there, but that would be an entirely separate presentation on reverse Williams' rule. But this is the McLean case that I referred to before. And again, this is that the offering party must prove that the person committed the collateral acts by clear and convincing evidence. And so here we discuss Alspeed. Alspeed is where the trial judge heard testimony that the defendant sexually assaulted her. They did allow the Williams rule in that case. However, the appellate court found that the victim's story was actually not credible, the Williams rule victim. It's actually not credible because, again, the defense attorney got out that this person had given different accounts to the police, that ultimately filed a waiver of prosecution, that the story had changed over time. And again, because of all of that, the trial court did allow that evidence in. Are going to be facing an uphill battle. Trial courts tend to allow Williams rule in, especially on sex cases. They're a little tougher on non-sex cases, but in cases involving children, because children are kind of inherently unreliable and they are not that specific, they do tend to allow Williams rule. Again, you have to file your written objection and you have to lay that very, very clear record because this is going to be an appeal. And really, half the time when you're arguing, when you're filing your motions, you're really addressing the appellate court because you're kind of assuming the trial court is going to get it wrong. So in that case, the trial court did get it wrong. So what kind of prior bad acts can the state use? So what about if it did not result in an arrest or prosecution? Yes, they can still bring that in. They can bring it in even if they never went to the police. And what if it resulted in a null pros? Yes, they can still bring it in because a null pros can happen if the victim becomes unavailable or they change their minds, and not necessarily because the state determines that the victim is unreliable. Can the state use collateral prior bad acts which were prosecuted, but your client pled out to a lesser, maybe a non-sex offense? Yes, I've had that happen. My client was on probation in Palm Beach for 2 victims. They were charged with sex cases. They pled out as child abuse. Then he was charged with the cousin down in Broward County. And we had a full Williams rule hearing. And yes, the judge did allow the testimony. However, he did limit it to just the portions that were similar, because in those cases, they were actually very similar, but there was force used, not one in the other. But it did not matter, legally speaking, that our client was not actually a sex offender. Can the state use collateral prior bad acts which were prosecuted but resulted in a not guilty verdict? No. So if a jury acquitted your client of the prior bad acts, no, the state cannot use those because the jury found your client not guilty. And here are just some additional cases that you can take a look at. Before we go into Rape Shield, I just wanted to go back into some of the other common plans and things. So again, we went over inextricably intertwined, same as identity. Now, absence of mistake. This is one, it's in there, it's absence of mistake or accident. I know when they're saying that this could happen, it's so rare. So absence of mistake, this would really be, I actually did have a case like this where the client claims that they were sleeping and they rolled over. There was the child next to them, and the child claimed that she woke up and that he was rubbing on her vagina over her underwear. So the fact that he had been asleep, the child had been asleep, theoretically, you can argue, look, the person was dreaming, or the person didn't realize what was going on, or maybe they thought it was their spouse in bed with them and not the child. So in cases like that, yes, theoretically, that could be a defense of mistake, a defense of accident. And so in those cases, the state might try to bring in a Williams rule victim to show that, in fact, your client has done something like this before, that it can't be a mistake because this has happened before, because this is a pattern. Now, the easiest way to attack this is, well, our client is accused of touching them inside of their underwear or penetrating their vagina with penis or with fingers. In those cases, mistake, accident, those are not defenses. No one's going to think that the person, held them down and forcibly had sex with them by mistake or they were dreaming. So those cases generally don't come in under absence of mistake. For opportunity, again, they try to bring this in, right? Family members saying that, oh, they've done this before. This is to show that they have the opportunity to do. Again, the easiest way to attack this is that the person that your defendant had unfettered access, right? So whether it's a family friend, whether it's a parent, or whether it's anyone who had been at the home before or at the place that this occurred. Again, opportunity would not be an issue in those cases, so it's disingenuous for the state to claim that they're trying to appeal into a victim for opportunity. So I had a case where it was, someone in the church. In those situations, it was a family friend. They saw each other at the church all the time. He went over to the home constantly. Opportunity was not an argument that the state could make because our client had unfettered access to the victim. As far as preparation or plan, is rarely seen. It's also called a common plan. I have not experienced those personally. That's usually with multiple defendants or to show maybe rope, to show that this is something that, again, preparation and plan can go hand in hand with modus operandi. All of these really are related, and when you do your arguments, you're going to be referring to all of them. Common plan or common scheme, again, you want to highlight the differences. In this case, showing that this was a plan, showing that there was preparation is not a necessary element, or that the other case is different. Again, when it comes to modus operandi here, this is easy, right? This is their MO. This is what this person does. But to show MO, you have to highlight all of the differences, right? So I had a case where they called him the Candy Man just because he sold Amway from his van in this neighborhood, and he would give the families chips or candy. But with one of the Williams Rule victims, he wasn't known to go to his van. This was alleged to have taken place in the home. So that one we were able to exclude because the MO was completely different. Even though they were similar ages, even though it was in the same neighborhood, even though the sex acts were very similar, the way it was carried out, the modus operandi, was different. So we were able to exclude that. Because remember, what you're arguing, this is a separate crime. This is a separate act. If the state wants to charge your client with that, they can. But we are talking about uncharged, about them bringing in a testifying witness in front of a jury is going to talk about another crime that they're not currently being accused of, that they're not currently being convicted. So it's not enough for the state to just say, look, it's clear and convincing that he did this other crime. They have to show why it is necessary, why they need to bring this in on your case, why it's going to be so probative that even though it's going to be prejudicial, that the probative value is so great as to outweigh the prejudice. And again, as far as knowledge is not an issue on most of these cases. Knowledge will be more for the adult cases because for children, it doesn't matter whether you know it's a crime, if you're from another country and over there it's not a crime, here it is, doesn't matter. The minimum mandate, you're still going to be prosecuted. So the big takeaway, let me just go forward a little more. Big takeaway for Williams Rule, out of everything, and again, I could do an entire presentation on just Williams Rule. It's very tricky, and you are going to see it very often in molestation cases. This takeaway is they have to file their written notice telling you more than 10 days prior to trial, telling you specifically what they're intending to prove. They will generally do the catch-all list. You should file your written objection, demand a hearing, take their depositions, do your investigation as if they were separate cases, as if they were separate victims. Our founding partner, Adam Rossen, is going to speak after I do. He's going to go into investigations in sex cases. So in that presentation, keep in mind, you're going to be investigating all of the Williams Rule victims as if they were separate victims, because that's in essence what they are going to be as far as the jury is concerned. So, with Williams Rule being covered, mostly, let's talk about Rape Shield. Now, Rape Shield, I'm sure a lot of you have heard about Rape Shield. Rape Shield, I've mostly seen Rape Shield when it comes to adult cases. It's a newer law. And you really should keep Rape Shield in mind, especially now we live in a post-Me Too era. So this is a biggie, and the state will file. They're going to try to preclude you from bringing in anything, right? They try to keep everything out, and then it's your job to bring in what's necessary for your defenses. And I should also add that if anybody has questions, just type them in. I'm going to save the last few minutes of the presentation for questions, okay? So this is Florida Statute 794.022. And this is specific instances of prior consensual sexual activity between the victim and any person other than the offender cannot be admitted into evidence in a prosecution for, again, the statutory crimes of sexual battery or child molestation or lewd and lascivious. And again, it's important to note here that the statute says there are instances between the victim and other people, not the offender, right? Because other instances with the offender can be included. Again, the state's going to say, all of this is to show that what the defense is trying to do here is to show that the victim was a slut, right? Slut shaming. That's not admissible. You're not allowed to say, well, your victim here likes to go to nightclubs and pick up strange men, and that's how it happened on your case. Well, that's what the state's going to say. But again, we're going to cover how you can bring in some of those if they are specific to your defense. Now, this is the however, right? However, such evidence may be admitted if it is first established to the court in an in-camera proceeding. So when the state files their Rape Shield preclusion, you're going to request, if there's things that you want to bring in that the state is seeking to preclude you from bringing in, you're going to request an in-camera hearing. And in that in-camera hearing, you can show, you can bring in certain things to show two big things. One is consent, and the other is to show another person committed the crime, right? So the first is you can do an in-camera hearing to show that such evidence can prove that the defendant was not the source of the semen, pregnancy, injury, or disease, or when the consent of the victim is at issue. Then such evidence may be admitted if it is first established to the court in the in-camera proceeding that this evidence tends to establish a pattern of conduct or behavior on the part of the victim, which is so similar to the conduct or behavior in the case that is relevant to the issue of consent. Okay, so let's break that down. This also says, notwithstanding any other provision of the law, reputation evidence relating to a victim's prior sexual conduct or evidence presented for the purpose of showing that the manner of dress of the victim at the time of the offense incited the sexual battery may not be admitted into evidence in a prosecution. This has been around for a while. You can't, basically this says, you can't say, well, she was wearing a short dress, she was asking for it. Okay, so let's talk about how you can get around Rape Shield, how you can bring it in when you show that it's specific to your defense. If you're arguing consent, right? So these are in adult cases where, yes, your client is saying, look, she said we could have sex, victim saying, no, I didn't. In showing whether consent is a defense, the state can bring in the victim's mental incapacity or defect, right, to show that it was not a knowing or voluntary consent. This is the victim was too drunk to consent, right? The state can bring that in when you're having, again, you'll have your in-camera hearing. You're saying, well, judge, we're going to present evidence that, she was kissing him at the bar. Witnesses were seeing this. But then again, the state can say, right, and we're going to bring in evidence to show that right before she did all of that, she had 10 shots back to back to back, or that possibly she was drugged. And that's where they might try to bring in a toxicology report. Also, if the victim on a rape case, on a sexual battery case, does ask your client to use a condom or any other type of prophylactic device, that does not mean that it's consent, and the state will preclude that. Will not allow the jury to hear that she said, please wear a condom, because it's not considered to be relevant to the issue of consent. Now, I cited this case here. This is Visa v. State at 489 Southern 2nd 36. It's a 4th District Court case from 86. Now, in that case, it was a child that was accusing her stepfather of sexual abuse. And the defense was trying to bring in the mother's testimony that she actually walked in on the child in bed with her brother, and that the brother was, and that the other person was nude. And so in that case, even though the child victim during the sexual assault examination was determined to have injury consistent with sexual battery, consistent with rape, the question of how that injury was caused and who caused that injury, that was the issue, and that was the defense. And in that case, the court determined that, yes, the mother's testimony that the daughter was in bed nude with her brother supported the reasonable inference that it was actually the brother, not the stepfather, that caused that physical trauma that was later identified. And so this was evidence that the jury should have heard. So again, don't be intimidated because the state files their rape shield preclusion and tries to prevent you from bringing it in. That's their job. That's what they're going to try to do. They want to handicap you and they want to cut off your defense at the knees. But again, all of these are very fact specific. You should have an in-camera hearing and try to explain to the judge why your evidence is in fact relevant, and that you're not trying to victim shame, that you're not trying to say she was asking for it, that this is a relevant and necessary defense. In this case, it was necessary to show the identity of the perpetrator. So certainly that she was in bed with someone else was completely relevant. And so in this other case, this is Dixon versus State, 605 Southern 2nd. I have the cites here. That was a 5-year-old victim. And again, with 5-year-olds, it's very tricky because they are given a lot of leeway. You will see that normally in any other crime, you will have a very specific information that states what date it happened, right? And it has to show with specificity what date it happened. But with child victims, the law is a little more lenient about that. They are allowed to give for a one count, to say it happened sometime in the summer of 2021. In adult cases, you're going to have to be a lot more specific, but with a child victim, they are allowed to give them more leeway. Now, in this case, though, it was a 5-year-old who actually had a lot of knowledge, had a lot of sexual knowledge. She knew the terms. She knew a lot of things that most 5-year-olds don't know. And so the defense in that case was fabrication. And so the court did rule that the evidence of the child victim's prior sexual knowledge, that was impermissibly excluded under rape shield, that the jury should have been able to hear that this child knew that. Why? Because again, everything is fact specific. In that case, you have a 5-year-old. If a 5-year-old starts using words, adult words, the jury is going to think, oh, they learned it from their client. They learned it because of this crime. That's how they learned all of these terms. And in fact, in Dixon, it was determined that that child actually knew all of that before. So that should have absolutely been brought in front of the jury, because the defense in that case was that the kid was making it up. So just because the kid knew certain terms, that doesn't mean that it was your client who was teaching her that, especially if you have evidence that this child, that's how they talk. And again, you just have to have the in-camera hearing, but you absolutely should do the in-camera hearing because otherwise you're not going to be preserving it for appeal. And so then we have Thorne versus State. Now, in that case, it was exclusion of evidence that the minor victim, during an interview, had accused 3 other men of sexually battering her and didn't actually accuse the defendant at first. That came after. So prior false accusations is what that case is about. And the theory of defense in Thorne was that the victim fabricated the allegations after he stopped giving her gifts. And so basically she was mad at him. And so she said, well, he raped me, right? So in that case, the evidence that she had falsely accused or that she had previously accused other people and those were not prosecuted or she took those back, that the jury should have absolutely heard it. Again, because the defense in that was fabrication. You have to explain to the judge how this is necessary for your defense. Obviously, defense's theory of fabrication, it is absolutely relevant that you didn't point the finger at your client first, that it was actually someone else. Or, for example, how the victim said it happened, right? How did the victim first accuse your client? So I had a case where it was discovered through depositions that it wasn't actually the child who said that our client, who was the neighbor, right, that our client touched her. It was only after the mother asked the child, who did this to you? How did you learn this behavior? Because that child was touching her baby brother, babysitter saw it, so babysitter tells mom, mom freaks out. You know, how did this young child learn this behavior? And then the father says, oh, she told me it was our neighbor. And because the child looked at the father when she was first asked this by the mother. And the state actually ended up dropping that case because they filed on it. I got him out in the Arthur hearing. I said, look, Judge, the identity is absolutely an issue here. You know, I think it's the dad. And the child looked at the dad when she was asked who did this. So again, all of that, right? All of that would be relevant. In that case, it did not go to trial. Luckily, I had a reasonable prosecutor who agreed that it was the father who put it all in her head, that it was our client, the neighbor. But that's something that the state absolutely wanted to keep out. Okay, so this is the last part of the presentation, which is child hearsay. So obviously this is not for adults. This is specifically for children. Under 16 is the law. So, okay. For hearsay, so obviously we all know hearsay is not normally admissible. Like I said earlier, when it comes to children, they are given a lot of leeway, and child hearsay can be admissible. Again, the state has to file their motion for child hearsay. You'll have a hearing, and we're going to go into that. But basically, for hearsay to be admissible under the child sexual abuse exception to hearsay, 2 things have to be shown. Both have to be shown. First, that the source of information through which the statement was reported has to be trustworthy. And second, that the time, content, and circumstances of the statement must reflect that statement provides sufficient safeguards of reliability. So what are we talking about here? 2 things. Both have to be shown. Trustworthiness and reliability, okay? So what you are looking at here, what your focus should be, is this source of information, right? Who is going to say what the child told them? Is this going to come out through a video? Is this coming out through mom saying, well, you know, she woke me up in the middle of the night and told me that this person molested her? So you're going to look at trustworthiness and reliability. Now, this is Florida Statute 90.80323. This is the child hearsay exception. It is a very limited exception to the hearsay rule. It is only for child victims, not for any general witnesses. It can apply to any type of abuse, so it's not just sexual abuse. It can also be aggravated child abuse or anything else of that type. And again, just like the Williams rule notice, the state must give you written notice no later than 10 days prior to trial. When you get this, object. Now, for child hearsay, you don't have to do a written objection. you simply ask for a hearing to determine the child hearsay. Okay, so what children qualify? It used to be that it had to be 11 and under for the child hearsay to be admissible. The law changed to the child only has to be 16 or less. Now, this can be the physical, emotional, or developmental age of 16. So I actually had a jury trial on an aggravated battery. It was an adult victim. However, she had the emotional intelligence of a 13-year-old. So in her case, they did attempt to bring in the child hearsay. I successfully was able to keep that out. But that was a big hearing. And the big reason was because the source of the child hearsay, the person who was going to testify about it, was not her case manager. It wasn't anyone that might be deemed trustworthy. It was her current boyfriend. So, that seems untrustworthy. So I told the judge, look, in that case, it was a testifying victim. She can testify to whatever she wants, but we can't now have her boyfriend saying that, well, she told him the same story. That would just be to corroborate it. That's bolstering, and that's completely improper because how trustworthy is this person? This person hasn't had any kind of training in how to question a child. That's really where you get into the reliability factors as well of child hearsay. So just specifically as far as the rule goes, the child has to either testify or be unavailable for the testimony. For unavailability, that has to be a finding by the court that the participation in the trial or proceeding would result in a substantial likelihood of severe emotional or mental harm. Now, for that, when it comes to emotional or mental harm, there are other safeguards that can be done. The child's testimony can be videotaped and then played to the jury. Ms. Lawson is going to go into a little bit of that. But there are other ways to do this rather than have the child not testify at all, because then the jury is hearing it from a third party. And, again, how reliable is that testimony going to be? You're not actually hearing from the victim, you're hearing from a third party. Or, in the inverse, if the child is going to be testifying, then the question becomes, why do we need this other testimony? State's going to say it's to corroborate the child's testimony. And here's where you have to look at, okay, if it's a 5-year-old, yeah, that makes sense that they would want corroborating testimony because 5-year-old's not really going to stand up to cross. However, you have a 15-year-old or a 16-year-old, right, who's going to testify. They're a testifying witness. Do we really need to hear the same story being told over and over again, no matter how reliable or trustworthy that source is and how that testimony is? That's just bolstering. That's just going to get that story out in front of the jury many, many times. And again, you're going to be arguing that that's overly prejudicial, and it's not necessary to prove the state's case. So that's something you want to watch out for bolstering and cumulative evidence. Again, set a hearing, object. And even if the judge does allow it, remember to renew your objections at the trial. All right, so when we're talking reliability factors, again, during the child hearsay objection hearing, that separate hearing that you're going to have prior to trial to determine if that child hearsay is going to come in or not. You're going to attack, well, not attack, but you're going to attack the credibility of the person who is testifying. So is this usually it's going to be a parent or a teacher, or it'll be the CPS worker, the Child Protective Services worker. So I had a hearing where it was a Child Protective Services worker, and a lot of people think that just because it's a CPS worker, that they are trained, that it's going to come in no matter what. In the trial that I had, it did come in. I don't agree with the judge. We ended up winning that case, so we didn't have to take it on appeal. But it would have been a good appeal because the CPS worker in that cross-examination during the child hearsay objection hearing, they are trained that leading children is very dangerous, right? So children are going to want to please authority figures. So if it's a police officer who is questioning them, because again, we're talking child hearsay, we're talking, is the police officer going to say, yep, this is what they told me happened? Is the parent going to say, this is what they told me? CPS worker, this is what they told me. Is that coming in? Well, how is that information relayed, right? because in the hearing that I had, the CPS worker was specifically trained that you cannot ask leading questions to a child. But you could see in the interview that she was getting frustrated. And what she was trying to get out is that there was blood on the sheets, right? This was a forcible rape on a 10-year-old where she was tied up and she was a virgin. So presumably a grown man who forcibly rapes a 10-year-old, there's going to be blood. There's going to be physical evidence on the bed sheets. And that's really what the CPS worker was trying to get out. And this child was just not saying it, was not giving her the answer that she wanted. And again, she was pushing and she was saying her original questions were proper. They were open-ended. They were, okay, how were you feeling? What did you see? But when she wasn't getting the answers that she wanted, she was saying, okay, well, was there anything on the sheets? The child was still not saying it. She said, is there any blood? And again, all of those, maybe not normally leading questions to an adult, but for a child who is inherently very suggestible, especially when it comes to an authority figure questioning them, these questions are dangerous because a child is asked the same question over and over, they're going to give you the answer that you're looking for, whether it's a parent, but particularly if it's someone in a position of authority, like a police officer. So be very careful with the videos, and they're going to be videotaped, whether it's CPS or if it's police, but scrutinize those. What questions are asked? Is the same question asked over and over? Is it asked in different ways until they get the answer that they want? It should be asked once, and they need to take that answer as it is. Again, especially if the child is testifying. The child's going to say that this happened, so we're going to allow the jury to see this other interview and hear the same story over and over again, even though they were leading questions? I don't think so. And if it's a parent, all right, well, when was this told to the parent, right? I had a case where the child had been getting into a lot of trouble at school, and the parent was asking them, what's going on? Why are you doing badly in school now? Why have you been getting detention? And then that's when the child said, oh, it's because I was raped by this person. So how reliable is that? How trustworthy is that? Is it because the child was trying to get out of being grounded by mom and dad in saying that, look, the reason I've been failing my chemistry test is because I'm actually having PTSD from this rape? Or is it because the mom kind of put it in their head? Again, just like the story that I told before about my client who accused the neighbor, it wasn't her that accused the neighbor, it was her father who accused the neighbor. And again, all of this is not going to be in the state's case in chief. You're not going to get this in a police report. This is you having to do your due diligence. And in these cases, you must have a hearing. Okay, and that puts us at 12:53, so that was actually a couple minutes earlier. So at this point, if there are any questions, I can take them now. Looks like I don't see any questions, so here's my contact information. Again, you can scan that and get all my contact information. I'm happy to help out. Criminal defense community is a small community here, and we support each other. So if you have any trials or weird fact patterns, you want to call us, I'm more than happy to help answer any questions.